Hello and welcome to Prof. Dale's Property video number 39. I'm your host, Dale Whitman. In this video, we're going to talk about the time of performance of a real estate contract. And by performance, we normally mean the closing date, the date when the deed will be delivered to the purchaser and the money will be paid to the seller or vendor. Our analysis of this issue of time of performance depends on whether time is of the essence in the real estate sale contract. And the answer to that question could be either way. Time either might be of the essence or not of the essence. In a way, it's like a switch that can be turned on or off, and normally the switch is flipped to either on or off by language in the contract itself. A simple statement in the contract that time is of the essence will make it so, and if there is no statement like that, the default understanding is that time is not of the essence in a real estate sale contract. Before we can analyze the situation with time of performance in a real estate contract, we need to get some principles of general contract law fixed in our minds. There are generally two kinds of contract breaches, material and non-material. A material breach is normally something quite serious, something that's quite injurious to the non-breaching party. And if a party commits a material breach, contract law says the non-breaching party, the innocent party, is discharged from the duty of further performance. In other words, they can walk away from the contract. They don't have to perform if the other side's committed a material breach, and the breaching party cannot enforce the contract against them. At the same time, the party who breaches materially is liable for expectation damages if any damages can be proven. Now, the other kind of breach, a non-material breach, is normally something that is less serious, perhaps almost trivial or minor in nature. And if a party commits a non-material breach, the non-breaching party, the innocent party, is still obligated to perform the contract, and the breaching party can still enforce the contract against them. Now, the breaching party is liable for any direct losses that are caused by the breach, if any such losses can be proved, but they're not liable for expectation damages in that situation. Now, let's focus our attention for a moment on a delay in tendering performance of a real estate sale contract. If time is not of the essence, then a reasonable delay in performance is a breach, but it's not a material breach. So if time's not of the essence, a breach of a relatively short period is not a material breach. An unreasonable delay, on the other hand, is a material breach. So that causes the courts to have to distinguish between a reasonable and an unreasonable delay. We'll talk about that in a moment. If time is of the essence, on the other hand, if that switch is flipped to make time of the essence, then any delay in performance at all, even a very, very short delay in performance, is a material breach. Now, as I said, that causes the courts to consider how long a delay has to be in order to be considered unreasonable. And the answer to that varies with the facts and circumstances of each case, but we can say generally that a delay of 30 days or even 60 days or probably even 90 days is considered to be a reasonable delay. In effect, what the courts are saying is that there are often delays in the closing of a real estate sale contract. So a delay of a few weeks or even a few months is considered to be reasonable. If we get out to the period of at least a year or more, then a court will probably find it to be unreasonable, although there are cases that are even exceptions to that. So we can't make a definitive statement about how long the delay has to be in order to be considered an unreasonable delay. But we can say that up to a few months, the courts will probably consider the delay to be reasonable, and therefore, if time is not of the essence, it's not a material breach to be that late. Why do people delay closing of real estate sale contracts? Either party may delay. The purchaser, for example, often has difficulty in getting a loan approved. They get jerked around by their lender. The lender says, we're working on it, but we can't tell you definitely if you're getting a loan yet, and that'll delay the closing. Sometimes a purchaser has other real estate that they need to sell in order to get the money to close on the purchase of this real estate. And if the other property doesn't sell quickly, that may delay the closing. from the point of view of the vendor or seller. Sometimes they have difficulty getting moved out of the property. The moving van people go on strike, or there are weather problems. Sometimes there are title defects that they have to clear up, and it takes time and effort and attorney's expense in order to clear those title defects, and so that may delay the closing as well. Now, there are many, many other possible reasons why either party might delay the closing. Those are just a few of the more common ones. If time is of the essence, as we've already said, any delay at all in performance is a material breach. Even a short delay will mean that the party who delays, who doesn't perform on time, is going to be committing a material breach, and that means that the late party is no longer able to enforce the contract. The innocent party is discharged from performing. The innocent party can walk away. The late party is also liable for expectation damages. Normally those damages are measured by the difference between the contract price and the market value on the date of breach. There may or may not in fact be any expectation damages, but if there are, the party who is late is liable to the innocent party for them. Now you might say, why wouldn't a party allow the other party some extra time to perform if they're late? Why would they be mean about it? For example, why wouldn't a vendor allow the purchaser additional time? Well, the answer often is that it's not in their interest to allow additional time. For example, many times if the purchaser is delayed, the vendor won't give them any extra time because the vendor has received a better offer from somebody else, which means they can sell the real estate for more money than they were going to get from this particular contract. Of course, in that situation, the vendor doesn't have any expectation damages because the market value on the date of the breach is actually higher than the amount of the contract price. So the vendor is happy to have the purchaser delay because that gets the vendor out of the contract so they can sell to somebody else for a higher price. If time is not of the essence, what damages will a vendor suffer from late performance by a purchaser? Now remember, expectation damages don't apply if time is not of the essence and the delay is only a reasonable delay. So what kinds of damages will a vendor suffer if a purchaser is late, but just reasonably late? Well, they might be having to pay additional property taxes on the real estate, additional insurance costs, additional repairs and maintenance, because they have to hold the real estate longer while they're waiting for the purchaser to perform. They might have a mortgage loan on the property, and if they do, they will probably have to pay additional interest on the mortgage loan in order to keep it in good standing during the period of delay. Sometimes they may forego interest on earnings on a cash purchase price. If the purchaser was going to pay them cash, then they could have invested that money and earned interest on it. Now they won't be able to do that until a little later because of the purchaser's delay. So all of those are typical aspects of non-expectation damages, direct damages, that result from a purchaser delaying closing on the contract. Bear in mind, though, that the vendor, if they have the property rented out and they continue to collect rent during the period of delay, they have to offset those damages by the additional rent that they're able to collect. What are the things that can make time essential or of the essence? As we've already said, a simple contract provision that says that, just says time is of the essence in this contract, will do it. On the other hand, a mere statement that there is a certain time for performance, that closing will occur on a certain date at a certain time, that in and of itself does not make time of the essence. In fact, the default rule, if that's all we have, is that time is not of the essence. But if we say time of the essence, it is. Now, other factors that can cause time to be of the essence. If we're in a market with rapidly fluctuating prices, so that prices are moving up and down almost daily or within a matter of a few days or a week, that's enough to make time of the essence for obvious reasons. Second, if time is very important to one party and the other party knows it. For example, if the vendor says to the purchaser, it's really important for me to close on time because I'm moving to San Diego and buying my condo the day after our closing here, and I need the money from this closing in order to pay for the condo. Now the purchaser knows the vendor considers time to be very important, and that's probably going to be enough to make time of the essence, even if the contract doesn't say so in so many words. Finally, a unilateral notice, and this is really quite amazing, a unilateral notice to the other party given a reasonable time before the closing date can make time of the essence, even if the original contract didn't say that time was of the essence. So either party can send this sort of notice to the other. If they do it a reasonable time before the closing date, they can make time of the essence. It almost seems like they're unilaterally modifying the contract, which we normally don't allow at all. But the theory is that here they're not changing the contract. They're simply saying that they're going to take the contract much more seriously than anyone thought before. Now you should know that most printed form contracts make time of the essence. They have that magic phrase in them. So if you have a client who's entering into a real estate sale contract using a printed form and they don't want time to be of the essence, they're going to need to strike out that language. The next two slides provide a summary of the time of the essence rules because the rules are fairly complex. On this chart, we're going to talk about how late a party is, what type of breach that represents, and what the consequences are. This chart represents the situation in which time is not made of the essence. So if a party is not late, then there's no breach at all, of course, and both parties can enforce the contract. If a party is reasonably late, that's considered a breach, but it's an immaterial breach, and the late party can still enforce the contract. They do have to pay those interim damages that we talked about, like additional property taxes, insurance, and maintenance costs. The innocent party cannot rescind the contract if the late party is only reasonably late and time is not of the essence. Finally, if the late party is unreasonably late, which as I said normally means a delay of at least several months, that's considered to be a material breach, and if there's a material breach, the late party cannot enforce the contract, and they're also liable for a loss of bargain or expectation damages. The innocent party can rescind the contract and walk away from it. Now, on the other hand, if time is of the essence and a party's not late, again, there's no breach and both parties can still enforce the contract. But if one party is either reasonably or unreasonably late, if they're late at all and time is of the essence, that's a material breach and the late party cannot enforce the contract and they are liable for loss of bargain or expectation damages, and of course the innocent party can rescind the contract. Now, if time has been made of the essence in the contract, how strictly must the agreed time be adhered to in order to avoid having a material breach? Well, let me give you one example. In Doctorman versus Schroeder, a very famous New Jersey case, the contract provided that time was of the essence and the parties had agreed to a 2:30 p.m. closing in a lawyer's office on a certain date. Unfortunately, the purchaser was held up in traffic and was 40 minutes late. The court said that the purchaser who is late even by 40 minutes has committed a material breach. The court allowed the vendor to cancel the contract, retain the purchaser's earnest money, sell the real estate to somebody else, which is really what the vendor wanted to do. No surprise there. So if time is of the essence, then the exact time of performance must be adhered to, or else there's going to be a material breach. Well, that completes video number 39 about the time of performance of a real estate sale contract. In our next video, number 40, we're going to talk about the remedies for breach of real estate sale contracts. If you have questions or comments, email profdale01@gmail.com. Thanks for watching.